go. Hopefully this will come in. Got that turned off. All right. Oof, does. All right. Good morning. Good morning, everybody. Hello. Or good afternoon. Hello. Hello. Welcome. Welcome. Hello. Good morning or afternoon. Hi, 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 everybody. This is kind of my lunch and learn time. Sometimes if I've got a whole bunch of things that we need to talk about, I like to come on and do like a lunch and learn. Is this American cheese? Oh my gosh, that's hilarious. That's hilarious. You know, I had a bad dream the other night that there were orange sticky notes chasing me. And it was like the bill on Capitol Hill was after me. It wasn't a good dream. Not feeling too strong. Okay. Well, that's all right. That's all right. Here we go. Yes, San Francisco. Oh, Siberio. I hope you can gain back some of that strength. Lots of rest, right? Lots of rest. Hello, welcome. Welcome in, everybody. All right, so I've got a little bonus today. I know it was an orange sticky note. An orange sticky note nightmare. They were coming for me. Now, for those of you that have been here for a long time, I had, I don't know, I had what was it, like a knuckle crunch, I guess. It was like a kind of a broken bone. I had a bad dream in the middle of the night, and my computer was next to me, and I punched it, and so I had crunched my knuckles. So I had to wear a brace for a while. Oh my gosh, the chats just gave me such a hard time, and rightfully so. Oh my gosh, memories, everyone. Yes, that was a long time ago, Betharoni, but it's all healed now. So just everybody keep your computers away from you when you're sleeping in case you have a bad dream. I thought there was like a car engine that was like coming after me. I don't know. Someone's always coming after me, and I had to get a new computer. It was just quite the to-do. Oh my goodness. Oh, thank you, Douglas. I appreciate that. Well, welcome in. Oh, Gucci French. Thank you so much. I've got my little sparkles today. We need a little extra shimmer. So, and your husband's, yeah, well, he's used to it. So he's built up a tolerance. But we're all right. We're all right. Well, welcome in. Hello, Deborah. Hello. So we have a lot of orders, everyone. We have a lot of things that are going on here with the closet docket, as I've been calling it, or the lawsuits against the administration. And this order came out just a couple days ago, and it's just really good. It is really, really good. And this has to do with the executive orders that they're trying to put into place in order to kind of not pay or punish the sanctuary cities is really how it's what it was really for. So with that, San Francisco's like, no, there's a preliminary injunction put into place, and then they were not complying with that. So San Francisco said, we need some clarification. Judge did a motion to clarify, and the judge agreed and set out this order clarifying that preliminary injunction. And I think the judge did a pretty good job here. This is where we have a lot going on in these cases where the government's kind of being, I don't know, like they're pulling in random words that may mean something else, or it's kind of like a like a poor sport situation, like we as attorneys, we all know how you could kind of manipulate words or manipulate things in order to, be a pest. So you're not really getting to the core issue, but you're kind of dancing around it in order to waste everybody's time. Like we all know what those are, but we don't use them because, that's unethical. But this administration is like, okay, we'll go ahead and we'll just use that and waste everybody's time. So the judge here was setting this up and saying, no, we've got stuff to do. So I thought it'd be pretty good. It's a short order, but very informative on how our judges are just saying, you know what, we're not going to deal with your bad faith stuff. We're going to need you to get that sorted out. I don't think we're going to have a suspension of habeas at all. I do not believe that for any minutes. For zero minutes. We're not there yet. We're not there. When has ethics ever intervened? Oh my gosh, excellent point. Good point. So let me go ahead and put my sticky note here. We've got city and county. Our judges, everybody, are starting to really get, like they've had enough of this. And they're really starting to explain that in their orders. So that's been enjoyable. San Francisco. And then I'm going to just I got to be careful about how I write that piece so that we don't have any problems. So there we go. And then if you want to look this case up, it is available for free online, as are all of our public documents here. So you are free to go and pull this case up yourself. And this document that we're doing today is 136. So I'll go ahead and add that on here, document 136. And it came out. Yes, our judges are and have been getting threatened quite a bit. And it's ongoing. It's ongoing. All of our judges in the cases, the criminal cases, with the exception of Judge Cannon in Florida, have all had problems. But the prosecutors in the Florida case, of course, were targeted. Judge Engeron in the huge New York civil case, there had been several things going on in that case. So there's been a lot. Right, that's a good point, Angela. He doesn't pay. True. Way back in the New York civil case, exactly. You got it. And I think actually Judge Engeron was late to the final day, I think, because they had sent out a particular kind of thing to his house. And so that kind of got, he was behind actually getting to the courthouse. So it's hard work, but, they're really earning their very low pay right now. But that's just kind of where we're at. Right, I don't see any of these cases. And again, we're at about 250 lawsuits filed against the administration, and I'm not seeing any wins at this point for the administration. I mean, there are some situations where, temporary restraining orders have been, vacated, or preliminary injunctions have been vacated, but no, I don't see any wins so far, but we'll just keep watching. And that's CJ Murphy trying to overturn the E. Jean Carroll. That's already got the full support in the Court of Appeals situation. So that particular case is pretty solid at this point. All right, so Texas judge. Oh my gosh, good point. So here we go, everyone. Let's just dive in. I've got kind of a shorter order here, just to hang out for a little bit and kind of explain what's going on. And then I will be back today. I will definitely be over on the Tube tonight at 8 o'clock Central, everybody, over on the Tube. I may do a pregame show over here. So if you want to hang out here before I head over there, that'll be good. But we have a lot of stuff going on. We got a lot of orders coming down. We have a lot of actual responses now. I would say over the last 3 days, I've seen more responses by the government than at any other time. So they're definitely getting their responses out there, and they're what we all suspected, which is inadequate, I guess would be the best word. So the arguments again are just very interesting. Like, well, we just don't think this should work this way. Like, well, do you have any case law to back that up? No, but we're just going to say it. Anyway, very interesting set of situations. So this is the city and county of San Francisco here, and we have, again, this is an order clarifying the preliminary injunction. Now, the preliminary injunction, of course, was put into place regarding sanctuary cities. That's what this case is about. And there were some questions. The original preliminary injunction had been filed on April 24th here. And I think this is really good to note. Down here, we have a footnote off of the title of the order, and it states, this is a summary order because of the exigencies it addresses. I will enter an order that discusses the issues and my reasoning in more detail at a later date. So the judge was like, wow, we got to put a stop to this right now, and then I'll come back and give you more of an explanation. And that was back in April. So what had happened was we did not have compliance with that order by the government, and so the City County of San Francisco said, hey, we're going to go ahead and file a motion for clarification. And then the judge just issued this order a couple of days ago. So I'll go ahead and dive right in, everyone. And just, I've got a lot of new followers. So welcome, everyone. I do request that you try to be civil, especially to my moderators. I have several moderators, and they work really hard, and I'm very thankful for their time. So if they're telling you to calm down, please do that. Okay. My lives are a good time to put the tiger back in the cage, all right? This is just informational, and then can be debated in other places. So here we go. Hello, Barbara. Good morning. You bet, Steffi, you bet. All right, here we go. Let's dive in. How will the litigation over sanctuary cities and federal funding unfold during the next 4 years? It's never good when your judge starts an order with a question. Everyone, that's never good. That's the unasked question that President Trump's executive order 14,287, protecting American communities from criminal aliens, hereafter EO 14287, which is aimed at so-called sanctuary jurisdictions and the cities and counties, motion to enforce, or in the alternative, to modify preliminary injunction, hereafter the motion to enforce, might bring to mind. To answer it and rule on the motion to enforce, I return to first principles. So he's taking us, we're going back to the beginning. We do have a footnote number 1 here that's listing out our plaintiffs. So we've got San Francisco, Santa Clara, Portland, King County, New Haven, Oakland, Emeryville, San Jose, Sacramento, San Diego, Santa Cruz, Monterey, Seattle, Minneapolis. Whoa, Minneapolis is all the way over here. Interesting. St. Paul and Santa Fe. So although it's brought under the name of San Francisco, of course, it's a huge group. That's what the et al. Is. So here we go. First, go into law. Well, I know there's a lot of people interested in that area. So for sure, the tiger's already out of the cage. Fair. First, the litigation may not proceed with the coercive threat to end all federal funding hanging over the cities and counties' heads like the sword of a Damocles or Damocles? Damocles. That threat was explicit in the first sentence of Section 17 of Executive Order 14157, in Section 2A sub 2 of Executive Order 14218, and in the preamble in Section 1 of the February 5th, 2025 memo from the Attorney General, Defendant Pamela Bondi, also called the Bondi Directive. And that is why they are enjoined. So he's putting all of these pieces together here. And I apologize. Let me double check and see who are judges. I am calling him a he, but it could very well be a she. So let's look real quick here just to double check and see who are judges here. I think I flipped this. Here we go. William Orrick. All right, so I'm going to take the creative stance that it's Mr. Judge, so we'll go forward that way. So with the Bondi Directive, and that's why we're enjoined. So he put all of those together here. Democles. Oh, thank you, Ali. I appreciate that. All right. Second, the government must proceed within the bounds of the Constitution. This whole order, this judge is not playing. That's the reason that I asked government counsel at the hearing on April 23rd of 2025 to confirm, one, that Congress has the spending power and the executive branch and its agencies cannot place new conditions on already appropriated funds. This is huge. This is where that constitutional crisis question continues to come up about, right? So he's saying, I asked the government this specific question. Two, that the president does not have unilateral authority to refuse to spend funds appropriated by Congress. And three, that conditions on federal funds must be unambiguous and timely. These again are the questions he's asking the government. That conditions on federal funds must bear relation to the funds at issue, and that the total financial incentive for compliance with federal immigration law cannot be coercive. So those are the questions, and the government agreed that those principles apply. And he cited the exact place on the transcript where the government agreed. All right, so the reason that's important, we may see this in multiple future cases involving federal funding, where the people are saying, look, government agreed to each one of these 5 questions that the judge asked. They already said yes. So there you go. Now, third, while complying with the first 2 principles, the government's entitled to identify particular grants and funding programs that it believes should be conditioned upon compliance with immigration-related objectives and to litigate its position. The preliminary injunction does not reach the litigation filed by the government against Illinois, New York, or Colorado, for example, nor does it prohibit efforts to enforce a condition regarding the Burn-JAG Act or other specific programs with a plausible nexus to sanctuary policies. With that, I turn to the motion to enforce. Now, just for clarification, if you're filing a motion to enforce, you're already in the red. The other party is not doing what they need to do. So this would be the equivalent of a motion to compel. So we probably have heard about the motion to compel, right? So if the other party won't give you documents, they won't answer questions, they won't work with you for discovery, they're refusing interrogatories, depositions, then what you would do is you would file a motion to compel saying, hey, we have a legal right to this information and the other side's not giving it to us. And so you file the motion with the court and the court comes back and says, do your job. You need to comply. So this is the equivalent when it comes to a preliminary injunction. So they're saying they are not complying with a court order. And so we're asking you to enforce this order. All right. So this is kind of the next step, because if another situation comes in and they don't comply with this new order, now we're looking at a contempt issue. All right. Here we go. Background. On April 24th of 2025, I issued the preliminary injunction in this case, enjoining the defendants, all listed here, and their officers, agents, servants, employees, and attorneys, and any other persons in active concert or participation with them, from taking any action to withhold, freeze, or condition federal funds from the cities and counties based on the first sentence of Section 17 of the Executive Order 14.159, Section 2 sub A sub 2 of the Executive Order 14.218, and the preamble and Section 1 of the February 5th, 2025 memo from the Attorney General, Defendant Pamela Bondi. So the judge is being incredibly specific here. On May 3rd of 2025, I issued a longer order expanding upon my reasoning for issuing the preliminary injunction, which is document 126 if you're interested. On April 28th of 2025, 4 days after I issued the preliminary injunction, President Trump issued a new executive order, EO 14287, which also concerns sanctuary jurisdictions and their receipt of federal funds. Because Executive Order 14287 issued after the preliminary injunction, I did not consider it in my decision making or in the more detailed analysis provided in the further order. A week after Trump issued EO 14287, the cities and counties filed the motion to enforce, arguing that EO 14287 repackages its predecessor's unconstitutional funding threats. Then we have footnote 3 down here. Sometimes we have some very interesting insights in our footnotes. Sometimes they're just citations. So after the cities and counties filed the motion to enforce an accompanying motion to shorten time for expedited briefing and hearing on the motion to enforce, I told the parties that if they could stipulate to the plaintiff's requested relief, at least until the matter could be fully briefed on a normal briefing schedule, I would hold a hearing on June 11th. Otherwise, I set an expedited briefing schedule and a hearing for May 8th at 3 p.m. Pacific time. At a case management conference at May 6th, the parties informed me that no such stipulation would be entered. So let me pause for a minute. The judge is saying if you both can agree, then we can do discovery in a regular way. So that would be a benefit to the defendant to not have to rush discovery, and then a benefit to the plaintiff by having, compromised and having some of what they needed dealt with. So he's saying if you guys can go make an agreement, then we'll just do a regular briefing schedule instead of a rushed, expedited discovery. Well, the parties were like, no, we can't agree. The government timely submitted its expedited response to the cities and counties' motion to enforce. I held a hearing on May 8th of 2025 at 3 p.m. Pacific, at which counsel for both the cities and counties and the government was heard. All right, so there's our footnote there. It is well settled that district courts have the power to supervise compliance with an injunction and to modify a preliminary injunction in consideration of new facts, citing case law here and Federal Rule of Civil Procedure 62, sub C through D. A party seeking modification of an injunction bears the burden of establishing that a significant change in facts or laws warrant revision of the injunction. And then there's further case law. So the party that's asking for changes bears the responsibility to prove to the judge that they really need those changes. So next is our discussion. Welcome in, Abuelito. I'm having my tang this morning, everybody. We're starting early with the tang today. Oh, thank you so much, Stephen. I appreciate that. Oh my gosh, thank you. Oh, that's adorable. At this early moment in the case, it is incumbent upon me to clarify the core purpose of the preliminary injunction, to ensure that litigation over how federal funding is allocated to the cities and counties is not driven by coercion and remains within the parameters of the United States Constitution. Executive Orders 14159 and 14218, which are the subject of the preliminary injunction, threatened to withhold all federal funding from sanctuary jurisdictions if they did not adapt their policies and practices to conform with the federal government's preference. That coercive threat and any actions agencies take to realize that threat is unconstitutional. So that's huge, and rightfully so. And this judge is absolutely correct to take it to that level of withholding funds. Now, I always give the example when it comes to funding, because people have said, well, we've done it in the past. Here's the deal. What has happened? Let me give you an example. We've got seatbelt laws, right? Now, the states were like, well, we don't want to have a seatbelt law in our state. We're, sovereign. We don't want to have that. And on our state highways. And so the federal government said, well, then we will withhold your highway funding then, right? Because we give funding for roads and stuff, but if our roads aren't safe because people aren't wearing their seatbelts, that's a problem. So states are like, fine, and came into compliance and had the seatbelt laws, all right? So that's one example of how that would work. They didn't say all of the federal funding for your entire state is done or we're taking back grants. They said we need a seatbelt law for the betterment of society, and if you don't do it, then we're going to have some problems. Now, the other example that I like to give too here is there can be any other kind of law, right? Like federally, prostitution is illegal. That's just how it is. And so they said to the states, we need you to make prostitution illegal. The other states are like, sure, why not? We can do that. And then Nevada was like, forget that. We got stuff going on here. And we want to make prostitution legal in our state, except for Reno and Las Vegas. So the government's like, you need to come into compliance, or again, we're going to withhold, highway funding. And the state of Nevada was like, we don't need your highway funding because the prostitution pays for our roads. So they were like, forget about it. You're not going to get to push us down this road. We want to have prostitution, so we're going to have prostitution. And that's what happened. Now, that's not legal advice. Double check and make sure your jurisdiction's appropriate when you're in Nevada. Maybe we could ask Legal Dad for the deets on that. But that, again, is just another example, right? So if you are wondering like, well, we've always done this before. True. And we've also done it with the drinking age, right? So some places are like, we're not going to change our drinking age. We're going to leave it at 18. And then they're like, well, again, federal roads, you're putting people that have been consuming alcohol on federal roads. So we're going to withhold that funding again, unless you bump that up to 21. So in the past, this has been used as a way to coax the states into coming into compliance for things like prostitution, drinking age, seatbelts. Now, what they're saying is you comply with our federal immigration policies, even if it's a state situation, or we will withhold all federal funding for your state. So this is a very different kind of situation where they're using one of the ways that we've used this in the past, and they're taking it well beyond the constitutional parameters. All right, so just to kind of clarify that. Oh, thank you, Kristen. Welcome in. All right, so here we go. It's unconstitutional, so I enjoined its effect. To be clear, while the letter of the preliminary injunction refers to specific sections, 14159, 14218, and the Bondi Directive, its spirit enjoins the kind of coercion that was evident at the time of the preliminary injunction's issuance in the language of those sections. The government cannot avoid liability down the line by hewing to the narrow letter of the injunction while simultaneously ignoring its spirit. So this is the moment when we see that this judge is calling the government out on it's that kind of like, I'm going to just call it Slick Willie which is what I refer to it as, that piece where they're taking words and manipulating them in a certain way. So it's not they're not necessarily wrong, but it's being done in bad faith, right? So if you know a circle is a circle and you're like, nope, we're going to call it a square because you only said circ instead of circle, right? So the judge is calling him out and saying, you knew what the spirit was. You knew what was going on. We had a hearing. We discussed this, and you are trying to manipulate the language in order to get around what you need to do. So that's that acknowledgement moment here. The preliminary injunction in this case reaches any subsequent executive order or government action that poses the same coercive threat to eliminate or suspend federal funding based on the government's assertion that a jurisdiction is a sanctuary jurisdiction. At the same time, the preliminary injunction was not designed to freeze litigation over the propriety of sanctuary policies or immigration-related conditions on particular government grants and contracts. The Ninth Circuit, for example, has held that the Department of Justice may include immigration-related factors when considering certain grants, which, that makes sense. A grant is different than congressionally allocated money that's been set out this way. So they're referring to the Los Angeles case out of 2019 discussing conditions on DOJ grants issued through the DOJ's competitive federal grant program under the Public Safety Partnership and Community Policing Act. With this in mind, I turn to the differences between EO 14287 and the orders already specifically enjoined. While addressing the same topic and seemingly targeting the same ultimate goal, ending or severely curtailing the issuance of federal funds to states and localities that limit the use of local resources for aiding in federal civil immigration enforcement, there are material differences between the challenged sections of 14287 and the sections of 14159 and 14218 that I enjoin. Here, so tang break. Section 17 of EO 14. Oh, sorry, everybody. Just a second here. I am waiting on a package from Montenegro. Nope, not for me. Okay. Sorry. Section 17 of EO 14159 and Section 2A2 of EO 14218 both direct the Attorney General and the DHS Secretary to withhold all federal funds from localities deemed to be sanctuary jurisdictions. Section 17 of 159, I'm going to start abbreviating, everybody, is 14 is the first number, okay? Section 17 of 159 directs the Attorney General and the DHS Secretary to, quote, evaluate and undertake any lawful actions to ensure that so-called sanctuary jurisdictions do not receive access to federal funds. That's pretty clear here. And Section 2 sub A sub 2 of EO 218 similarly directs the head of each executive department or agency to ensure that federal payments to states and localities do not facilitate the subsidization of or promotion of illegal immigrants or abet so-called sanctuary policies. These provisions' respective broad scope drove my conclusion under binding Ninth Circuit authority to issue the preliminary injunction. In so finding, I rejected the government's arguments that those orders merely provided guidance for executive agencies conducting evaluations of localities as federal funding as a disingenuous read of their plain language. So again, everyone, we have this judge calling them out for this bad faith use of trying to manipulate the language. And I rejected its argument that the order's savings clauses insulated them from judicial review. To give such weight to those clauses would require looking past the orders as clear and specific language directing unlawful action, which I cannot do. Executive Order 287 is different from 159 and 218 in some ways. Section 2 of 287 calls for the Attorney General, in coordination with the DHS Secretary, to publish a list of states and local jurisdictions that have identified as sanctuary jurisdictions. And we have footnote 4 here. It says here, Section 2A directs the Attorney General, in coordination with DHS Secretary, to publish a list of states and local jurisdictions that obstruct the enforcement of federal immigration laws. So sanctuary jurisdictions here. So sanctuary jurisdictions, and to notify, and we've got footnote 5. Section 2B directs the same agency heads to notify each sanctuary jurisdiction regarding its defiance of federal immigration law enforcement and any potential violations of federal criminal law. Those jurisdictions of their status on the list. In contrast with Section 17 of 159 and Section 2A of 218, nothing in Section 2 of 287 directs executive agency heads to withhold from, freeze, or condition all federal funding to sanctuary jurisdictions on their compliance with federal immigration law. It directs them to identify those jurisdictions that qualify as sanctuary jurisdictions and notify them of their inclusion on the list. This will at least resolve the ambiguity of what jurisdictions the government considers to be sanctuary jurisdictions and puts those states and localities that qualify on notice. So again, this is a huge constitutional crisis situation here, if we were to use that terminology, because we have the federal government forcing states into a corner and saying you're going to lose all federal funding if you don't do what we tell you to do. There's nothing improper about Section 2 here. And then, by the way, there was another order here. So flipping to page 6, Section 3 of EO 287 is closer to the enjoined sections of 159 and 218. It lays out consequences for sanctuary jurisdiction status. Section 3A provides that with respect to sanctuary jurisdictions that are designated under Sections 2A of 287, the head of each executive department or agency, in coordination with the director of the Office of Management and Budget, and as permitted by law, shall identify appropriate federal funds to sanctuary jurisdictions, including grants and contracts for suspension or termination as appropriate. 3, and that's under 3A. In Section 3B, it says that after notice under Section 2B, the Attorney General and DHS Secretary shall pursue all necessary legal remedies and enforcement measures to end these violations and bring such jurisdictions into compliance with the laws of the United States. So if you don't do what the federal government tells you to do, states, then we're going to do whatever it takes to bring you into compliance. While the government asserts that Section 3 does not direct actual termination or suspension of funds, a fact sheet published by the White House along Executive Order 287 explains that President Trump signed 287 to enforce federal law with respect to sanctuary jurisdiction. States that sanctuary jurisdictions that do not comply with federal law may lose federal funding, and quotes Trump's Truth Social post declaring his intent to end sanctuary jurisdictions. And then we're doing an exhibit here where he's quoting the White House fact sheet that's entitled Cracking Down on Sanctuary Jurisdictions. So that's something else that's really interesting too that you might take note of is, typically when we're dealing with, regular criminals that are at a higher level. So like white collar crime, well, that's not true. That's not a higher level. That's just not true. When we're dealing with criminals, the experienced criminals or the ones that wish to get away with it are very careful, right? They don't confess. They don't leave evidence, right? They're very CSI oriented. They're like wearing gloves and those kinds of things because all of that can be tracked back to them. So you would think that when you're doing something, that's clearly wrong, that you would kind of cover your tracks or you wouldn't publish it. But that's incorrect with this administration. It's all out there in the open. And that is more alarming because what they're trying to do is make the wrongdoing right. They're trying to say, well, we're not doing anything wrong. Look at everything that we're doing. This is how things need to run now. And that is really what's concerning here. All right. But it's not because there's a lack of evidence that they are not following the law. It's because they are now trying to change what the law means. Right. Right. I mean, and they're trying to actually change how things work. That said, some aspects of Section 3 may resolve some of the problems I described pertaining to the overbreadth of 159 and 218. Identification of the funds the government believes are at issue would, if done in a constitutionally targeted way, provide clarity. The requirement to identify funds for potential rescissions by itself is not inappropriate, following an evaluation of the type of funding involved to determine if there is a nexus between the funding stream, the jurisdiction's policies, and desired immigration-related conditions, as the government is constitutionally obligated to do before it acts. So again, talking about that seatbelt rule, obviously federal road funding and seatbelts, kind of go hand in hand. So they're saying if you can be more specific and do it in the right way, then do it, which I think is what all of us have been screaming the whole time. Right? So if you want to be a jerk, but do it constitutionally. What would be inappropriate is if the criterion for identification of funds for suspension or termination was the fact that the so-called sanctuary jurisdictions received them. If the government were to take the unconstitutional approach of flagging all federal funds or funds unrelated to sanctuary policies to those states and localities the Attorney General and DHS Secretary determined to be sanctuary jurisdictions as being appropriate for suspension or termination, it would violate the Constitution in the same way that the enjoined sections of 159 and 218 do. Right? That approach would violate the preliminary injunction. The government argues that 287 only calls for the publication of a list, the notification of jurisdictions on that list of their presence on it, and identification of funds for possible suspension or termination, but that it does not direct for actual termination or suspension. 287 does not direct executive agencies to freeze all federal funds to the jurisdictions like the cities and counties, but the context surrounding this executive order and its predecessors raises the threat that the government will employ these executive actions to unconstitutionally coerce the cities and counties and other jurisdictions like them into changing their policies and practices to conform with the second Trump administration's preferences. President Trump's actions, communications, and representations about sanctuary jurisdictions have made it perfectly clear that his ultimate goal is their elimination. Directives from executive agencies in his administration have put finger points on his have put finer. I was like, what do you mean by fingers? Everybody. Hold on a second. I'm going to need to pause. Just one moment. Okay, thank you, everybody. Whoo, sorry, I've got to keep my eyes out for this particular package. I'm sorry. Oh my gosh, it's coming all the way over from Montenegro. So, all right, where were we? Here we go. Perfectly clear. Okay, so let's pick up here. Thank you all for waiting. Let's dive back in. So, President Trump's actions, communications, and representations about sanctuary jurisdictions have made it perfectly clear that his ultimate goal is their elimination. Directives from executive agencies in his administration have put finer points on his often informal expressions. And then citing the further order discussing actions and communications surrounding 159 and 218 that gave rise to the cities and counties' reasonable fear of the enforcement. Since I issued the preliminary injunction, the executive branch has compounded the concern that it will wield the latest executive order to cut off or coercively threaten to cut off all federal funds from so-called sanctuary jurisdictions. The White House fact sheet published alongside 287 proclaiming that through 287, Trump is following through on his promise to rid the United States of sanctuary cities. And quoting a Truth Social post from the president wherein he stated that he was working on papers to withhold all federal funding for any city or state that allows these unalive traps, referring to sanctuary cities, to exist, does not inspire confidence in the government's representation that it will limit its implementation of Executive Order 287 to identification of funds for suspension or termination. So see, it's their own language, the administration's own language and postings that are showing like what the government is saying in court is not what's actually occurring. The preliminary injunction is not intended to hamstring the government's lawful evaluation of federal funds to states and localities that have sanctuary policies. It seems relatively easy to identify categories of funds that have little or nothing to do with sanctuary policies, such as healthcare, transportation, emergency relief, and so forth, that would have an unlawfully coercive effect on the cities and counties if those categories of funds were identified for suspension or termination. To do so would violate the preliminary injunction. As the government's counsel acknowledged, the preliminary injunction reaches the government's prescribed conduct, whether it's based on 287 or some as yet unpublished executive order. In light of all these considerations, I clarify that neither Executive Order 287 nor any of the other government actions that postdates the preliminary injunction can be used as an end run around the preliminary injunction order. The language based on the first sentence of Section 17 of Executive Order 159, Section 2A, Sub 2 of Executive Order 218, and the preamble of Section 1 of the February 5th memo from Attorney General Defendant Pamela Bondi shall be read to apply to any executive order or agency directive that purports to attempt to cut off federal funding from states or localities that meet the government's definition of sanctuary jurisdiction in the wholesale, overbroad, and unconstitutional manner threatened by Section 17 of Executive Order 159 and Section 2 Sub 2, 2A Sub 2 of Executive Order 218. So that there is no failure of communication. Wow, this judge is super upset, everybody. This is really, oh my goodness. Oh my goodness gracious. So that there's no failure of communication. The defendants are instructed to provide written notice of this order clarifying preliminary injunction to all federal departments and agencies by May 16th. It's so ordered. Oh my gosh. So the judge is like, not only is this like not okay, but I need you to show that you have sent written notices out of this order to all federal departments and agencies. Oh my goodness gracious. Yeah, this judge isn't playing around anymore here. This is the second clarification order that had to be done. And he's like, you know what? You're the plain meaning of the language. You know full well what it is. And you're just kind of, messing around here with everybody. So, I like this judge too, Deborah. I do too. Very direct. Exactly. Exactly. And we're going to see that more and more with these cases. We're going to start, like judges, typically what I personally have found is that judges will give you a couple of strikes. They'll be like, yeah, all right, you're kind of being a jerk, but fine. They'll give you a couple of shots at it, but then they reach a point where they're like, we're done. And there's no coming back. Like you can't fix it after that judge is like, we've had enough. So you have to be careful because you walk that line between like just, being able to, get in there with kind of your semi bad faith reasoning. But once you hit that wall, that judge is not going to take it. Oakland, Portland. Yes, exactly. Yes. So this is, of course, an et al. Case. And let me move my sticky note out of the way so you can see the different places here that are included in that et al. Yeah. Can California stop paying federal taxes? That's a good question. And my answer would be no. Not constitutionally. And but it's complicated. There are some things that states can do to insulate themselves from the federal government, and in fact, quite a few things. But for federal taxes, that's going to be kind of a step-by-step situation. There may be some things they can kind of untangle themselves from, but overall, to just be like, man, we're not going to pay federal taxes anymore, that would not be legal under the federal code. Yes, although it presents an interesting question, though, doesn't it? A very interesting question. And we've had several cases come forward where people have said, I'm frustrated. I don't want to pay taxes that are going to support this situation. And the courts over and over and over again have said, usually your tax money needs to go wherever Congress puts it. So, but then we've also had some that have been a little bit more lenient, saying, well, all right, maybe. But we don't have a confirmed hard no on that. Is Colorado part of the suit? No, I did not see Colorado in here. City of Emeryville, that's in California, right? Jose, San Diego, Sacramento, Santa Cruz, Monterey, so Seattle, Minneapolis, St. Paul, Santa Fe, here, Portland, yeah, so I think that's it. Yep, okay, yeah, So that's in the Bay Area. Okay, thank you, MT, I appreciate that. Yeah, I mean, it's, again, we've got a lot of the lawsuits, and I would say, again, the most shock and awe type situation where we've got significant overreach of executive power are going to be in the Alien Enemies Act habeas corpus cases. That's where it's just so clear. It's so clear that there's an executive power issue. But the ones that truly will have lasting, that are really getting into try to pull the roots of the democracy up are these cases where Congress has set out funding and it is not being distributed or is being withheld or canceled, those kinds of things. That's truly where the fight for democracy is. So when they're saying, well, we're not going to give you federal funding because you're not complying with these immigration laws that are, procedures that we think you should, that's huge. That's a state sovereignty issue, right? So, and we had this problem before in his previous administration where there was this fight between the federal government and the state government when it came to what resources the states were going to use to assist the feds in their immigration situation. Now, some states don't have any problem with that, but then some states do. And it should, again, it's up to the states and their sovereignty on how they want to deal with it. Yes, exactly. Yes, the fourth largest. Yeah. What cases do you think we will get rulings on Monday? I think there's opinions scheduled on Monday. So, good question. I've been looking at, our the cases that are getting most of the movement are the ones that have already been appealed, but we have oral arguments on the birthright citizenship case set for the 15th, I believe. I believe that's right. I'd have to double check the closet. But we do have that. That's probably the biggest one right now coming down. This will be appealed without a doubt. This may be one of our biggest cases for this federal funding question on that. Yes. Yeah. Oh, it's on the way. What the hell? It's on the way. There's so many new municipal and state agencies that signed. Yes. Agreed. So a lot of the newest lawsuits that are being filed, and again, we're getting handfuls of cases filed every single day. It's happening almost every single day. That's how we're at 250 lawsuits in like 100 days of the administration. And there are multiple suits, usually against whatever executive orders have just come out within the last week. So we've had some questionable ones that have come out. They're all kind of questionable, but recently, and when I take a look, when I've gone through just the tariff executive orders and how they've tried to, they changed the puzzle back, everybody. Hold on a second, everyone. Oh my goodness, thanks for changing the puzzle back, TikTok. Oh my goodness gracious. So with the tariffs situation, and I think there were like 4 of the 12 tariff executive orders, or 4 or 5, are just on China. And I mean, it's just like, it blows my mind when I read it, because it's like, who's writing this stuff? But anyway, so that's a slow ongoing process of the tariff lawsuits, but I would say there's more lawsuits every day coming in. Yay, I know, Willie B. I get nervous about that. Yikes. Personal courtroom at this point. Right. So there's some let me grab a docket over here that I printed out that's absolutely fascinating. I mean, from a purely academic point of view, horrifying, but, from an academic point of view, it's pretty interesting. Here we go. Let me see if I can get this. It's in the other room, so I won't pull it at this moment, but, every single thing is being appealed, and as much as they possibly can. And that, again, clogs up the whole system. You have a right to appeal stuff, absolutely. But when you think about all of the appeals and all of the paperwork, all the fight is being done by the Department of Justice, like, that's huge. That's a huge piece that they're doing. And one thing, there is a creator on here, oh my gosh, and I cannot remember her name. She has been tracking all of the pardons. She had worked as like the pardon person in the Department of Justice, and she's going through basically and explaining how much money is being dissipated, right? And then, of course, with the Jan 6ers, none of those fines or restitution, none of that will be applicable. But all the funding, and then with the pardons for people who were convicted and have huge fines. I think there was one person that had like $500 million in fines or something along those lines. They don't have to pay it, because once you've been pardoned, like, your restitution's done. So it's mind-blowing. So not only are we completely overrunning the DOJ with all of these lawsuits against the administration, but we are also then pulling money out because of that. So she's amazing. She is amazing. Yes. Oh my gosh, I just don't remember her name. It might be Liz Oyer. That might be right. Oh my gosh, I apologize. She's really getting quite the following, everybody. So she's, yeah, I think if you just search DOJ pardon officer, she'll come up. Over a billion. Yes, yes. Okay. Not even being held responsible. No, no, none of the damage. None of the damage. Okay, thanks, VC. None of the damage. All, you had restitution damage done during J6th. And so you had to pay that, right? You had to pay for the damages that you did and the court costs, all of that stuff. That's zeroed out when you're pardoned. That's zeroed out. And so all of these super rich people who are being pardoned, right? And a pardon doesn't mean you didn't do it. A pardon just means, yes, you did it. You were convicted of it. You're supposed to pay like, $1 billion, but, we're going to go ahead and take it off your record. So that's what that means. It's definitely overwhelming. Oh, Jasmine, of course. Representative Crockett. Oh my gosh, Crockett. She's amazing. That's her. Just looked her up. Okay, excellent. Excellent. Thanks, Barbara. Yeah, so she does great work. And I just love how she presents it. And it's probably because of my lawyer brain. She's just comes on and she's like, well, 1, 2, and 3, we just lost, $500 million. So next. I just love it. Oh, she does such great work. We just keep paying for them over and over again. Absolutely. Absolutely. Okay. At lawyer.oyer is her hand. Okay. Okay. Excellent. Oh, I'm so glad you all could assist with that because she's just great. I mean, I've only really come across her in the last couple of weeks, but she does amazing work that I've seen. That I've seen. I think she's just very, very credible. Breaks it down in a way that's easy to understand. And it's a lawyer doing math. I mean, are you kidding me? It's like she's a unicorn. She's very special if the lawyer's doing math, right? Oh my gosh. So anyway, by the way, BTW, I will be back again over on the tube tonight, everyone, at 8 o'clock Central, and I will be going through the most recent filings in the Garcia case. We have a memo from Garcia's team going through and explaining how the privilege that they're trying to use, so the state classified documents or whatever privilege that they are trying to use is not appropriate. So this will be my reading for tonight. I still have quite a bit of other documents and things that I need to kind of get everybody caught up on. But for tonight in particular, I know a lot of people are wondering about the Garcia case. Right. Hey, no worries. No worries. All of my lives over on the tube are under the live tab, so you can go in there. And then all of my TikTok lives, I post just as regular long content over there. So you can usually catch all of them. I'm just a little slow getting everything done. I'm just kind of a one-woman show here, and it's like, lights, camera, action. It's just me, so... Yes, on the tube tonight. Yes, well, and again, this is the answer. What's with the Garcia case, everybody? What to keep your eyes on right now? They're trying to get 2 more depositions done. We're waiting for confirmation of that. And then once the last 2 depositions are done, once it's all wrapped up, which I think will be done by the end of this week, in all honesty, then we're going to start seeing the orders. We're going to start seeing, because what happened was Garcia's team deposed the 4 people, the 4 big ones that were writing the declarations, right? They deposed them. And information came out in those depositions that opened other doors for the Garcia team to be like, wow, we need someone from Homeland Security. We need someone from the DOJ, because these answers have opened these doors about what you're doing to facilitate the return. And so and that's exactly what was predicted by the judge. She was saying, look, once you sit down for these depots, they may open doors, and that is what's happened. That kind of, those answers, that kind of information is of course being sealed. In fact, I think we've got pieces in here, yes, and I'll go through that. But even in their filings, they're referring to the information that they received in depots, but they're having to redact it. So we're not going to be able to see the full story on this until those become unsealed. But we know Garcia's team is getting that information. And so that's huge. Oh, you're welcome. You're welcome. On LinkedIn and see that Todd Blanche is oh my gosh. So, oh my gosh, my goodness gracious. Yeah, that's another thing too that's going on right now is the Library of Congress is, I guess Blanche is trying to get into the research, or the head of the Library of Congress. Like, I don't know, man. All I know is that I've got caricatures of him trying to defend that Stormy Daniels situation that happened in New York, and just getting yelled at by the judge. I'll never be able to take him that seriously after that. Oh, you're welcome. You're welcome. Hello, Phoenix. Welcome. 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 How's the House of Cards? Right. I think so, Navy vet. So here's the deal. I think the House of Cards was weakening. It was getting weak as soon as the contempt finding, the probable cause contempt finding out of DC occurred in the JGG case. That was the first wobble, I guess, is what you would say. The next one was when Texas said, you can't do this with the AEA. That was huge. That was huge. So when Texas did that with the AEA, and then our judge on the Perkins case regarding the law firms, those two pieces, yeah, it's starting to crumble. And you can see the exhaustion in the Department of Justice as well. You can see the exhaustion if you take the time, which I try to do with everybody here, when you take the time to read through what they're filing, it's just, it's, oh my gosh, especially now that responses are coming in, you just can't cut and paste 250 cases that are unique. You can try, and they are trying, but no, they're exhausted. They're absolutely exhausted, and you can tell. They're burning out. They fled the zone, but the problem when you flood the zone is that you too are in the zone, and you too get flooded. So it's, you can try, but the thing too about the justice system, everybody, is that it's slow, but it's like a tank. It keeps going and will destroy everything in its path. And so we have to remember that. It might take some time, but by the time that tank gets to your front door, like, you're done. Your situation is over. Right. Oh, sorry, everybody. Just 1 second. All right, everybody. Sorry about that. All right, we got it. We have what we needed from Montenegro. Sorry about that interruption. All right, last one. That was the last one. Yes, it's a busy spot. I know. Oh my gosh. Yes, of course, Willie B. Of course. So yes, we're back. All All right. So I guess what I'm putting out is saying that it's crumbling. We're there. We're absolutely there. It's they're just not able to keep up with it. So, friendly reminder, we have lawsuits against all of the tariffs. We have the birthright citizenship lawsuits. We have the transgender military and passports and all kinds of things, discrimination cases that have been filed, the DEIA cases. We have the USAID cases, the radio cases. It's just a lot. All of the Doge cases are still going. All of those. There are some that are just against Mr. Musk. All of those cases are still up and running through the process. And then, of course, one of the biggest categories, the federal employees. Those federal employees who were, you know, canned essentially, have filed tons of lawsuits, all the way to the inspector generals, right? That was the first moment when everyone's like, wow, that executive order's not right. That lawsuit's still going. And then, of course, Harvard, multiple lawsuits against law firms, or the law firms coming in and so on. So these cases are still going. They're still going. They're not hitting the news. They're not sensational at the moment because it seems like, what's the daily flavor? But they're still going, every single one of those cases. And each day something a little different works its way through the process. We've had maybe 5 cases that have self-dismissed or have finished on their own. They've just are like, we're done. But other than that, we just are, every day setting it up and knocking it down. It's huge. It's a huge amount. Yeah. I mean, we just, I don't know. I don't know. This particular birthday's not that happy. We're struggling. We're struggling, I think, with this sense of togetherness. But, this idea, and this will be my wrap-up thought for today, everyone, for today's Lunch and Learn. This idea of giving it back to the states, right? They're doing all these weird things where they're like, oh, let's give the power back to the states, blah, blah, blah. Meanwhile, they're also doing things like the SAVE Act, where they're removing power from the states and giving it to the federal government. So it's like, what do you mean? What are you even talking about? But this whole idea of the power of the states versus the power of the federal government, that's what the original problem was with the Declaration of Independence and how the country was put together. Like, that has never truly been resolved to a point where it won't be an issue. And I think it will always be an issue, but how we deal with it will change as time goes on. So that's truly the issue. Exactly. All things Alicia. I apologize. Absolutely. Right. Not giving the money. Exactly. And that was one of the big points in this case today that we're going through, is the judge is like, you can't just threaten all federal funding. Like, that's not how this works. So whoever told you could do that was wrong. I think I have some ideas of who that was. I don't know. Let me see if I have a picture of my guess of who was saying that. Oh, let me see. Wait, do I have it in here? I don't know. I may not have kept it. Let me see as I close today. Just 1 second. I don't know. I must have put the chart away. I had a really fun chart that I like to bring out, but it scared people, so I think I put it away. Anyway, apologize for that. But yes, I think they're getting some bad information. Voldemort. That's funny. I don't know where I put it. That's so weird, right? Oh my goodness. gracious, where did it go? Was a really good one too. I don't know. I think I had to figure out how to take off the. Well, here, we'll just do this one. I'll just put this one here instead. Here's my little puppet. Right? Oh my gosh. So attorney, yeah, so Miller is not an attorney, right? I mean, that was mind-blowing. I know, exactly, cosplaying. All right, everyone, with that, I will probably be doing a pregame show tonight before the 8 o'clock Central over on the tube, so I'll probably be back here later. But thank you all for coming by today, and I'll be keeping an eye on this case because it's a pretty big one. So take care, have a great rest of your day, and see you all later tonight.